Whether you have an employment, criminal, family, corporate, or personal injury matter, legal issues can be puzzling. The lawyers at Devry, Smith & Frank make all the pieces fit together.
Good morning, everyone. My name is Marty and I'm another one of the employment lawyers here at DSF. And I've dealt with a number of human rights cases in the employment context, so I will be speaking about the employer's duty to accommodate employees in the workplace. Now, Alexander has spoken a little bit about human rights legislation already. So the long and short of it is that employers cannot discriminate against employees in the employment context based on a number of grounds. And those are things like age, gender, religion, place of origin, sexual orientation, disability, and the list goes on. So in Ontario, we need to look at the Human Rights Code to determine an employer's obligations towards its employees. And for federal employees, such as airlines, railways, telecommunications companies, we need to look to the Canadian Human Rights Act. Now, issues involving an employer's duty to accommodate an employee typically arise when that employee has been diagnosed with a medical condition or has sustained an injury and is no longer able to perform all or some of their employment duties. And this would fall under the ground of disability in the Ontario Human Rights Code. Now, the definition of disability in the Human Rights Code is actually quite broad. It includes a number of things. The first is any degree of physical disability, infirmity, malformation, or disfigurement that is caused by bodily injury, birth defect, or illness. It also includes mental impairment or developmental disability. And finally, learning disabilities are also included. So now I'm going to get into when this duty to accommodate is triggered and what exactly it entails. So when an employee advises their employer that they have a disability, as defined in the human rights legislation, and provides supporting medical documentation, then this triggers the employer's duty to accommodate. Now, the employer is going to be entitled to information required in order to provide the accommodation. So, for example, they'd be entitled to know that an employee, say, has a back injury, which prevents him or her from doing heavy lifting. But the employer would not necessarily be entitled to know the specific diagnosis. So, for example, if the problem was a herniated disc, they might not be entitled to know that because all they really need to know is there's a back injury in this example and it prevents that employee from doing heavy lifting. So a few quick examples of what an accommodation could look like: no heavy lifting, maybe giving the employee some time off to attend medical appointments, and if you have an employee who is vision impaired, perhaps translating certain documents into Braille so that employee can read them. Now, the employer may actually be required to pay for the cost of certain accommodations. So some examples of that: if you have the employee who can no longer do heavy lifting, the employer may be required to hire someone else to do the heavy lifting. Or in the case of having documents translated into Braille, there's going to be a cost for that, which the employer may be required to bear. In determining the appropriate accommodation in a particular case, the employer should discuss the situation with the employee, review the medical documentation that the employee has provided, and maybe even discuss the situation with the employee's doctor to figure out what the appropriate accommodation should be. Now, it's significant to note as well that it's not sufficient for the employer to simply respond to accommodation proposals that have been presented by the employee. The employer also needs to take initiative in proposing accommodations. Now, the duty to accommodate does have limits. The duty to accommodate only goes up to the point of what the law refers to as undue hardship for the employer. And if the employer wants to argue in court that a particular accommodation would amount to an undue hardship, it's the employer who would have the burden of proof. Now in Canada, a proportionality approach is used to determine whether there would be undue hardship for an employer. So any harm is not going to be enough. There has to be an excessive or disproportionately severe degree of harm to an employer before this notion of an undue hardship or an undue burden would kick in. A number of factors will be considered by the court in determining whether there is going to be an undue hardship. One factor would be financial losses, so for example the cost of hiring additional employees or even increasing the wages of other employees if work would need to be distributed to accommodate an employee with a disability. And another issue the court would consider is workplace morale. Now this notion of undue hardship would probably kick in more quickly for a smaller company than for a larger company. So larger companies that have more money, more resources, more employees would be expected to provide greater accommodations than, say, a smaller company with only 5 or 10 employees and not enough or insufficient financial resources. So for example, it would be less of a hardship for a large company, say like Bell or Rogers, to hire additional employees or to spend money on some sort of specially designed workstation, for example, to accommodate an employee with a back or wrist injury. And here's an example about workplace morale. Let's say you've got a receptionist at a company with only 10 employees. The company is just starting up. This receptionist has an illness which regularly prevents him or her from coming into work. This employee provides very little notice of her absences, and as a result of this, other employees are required to cover the reception duties in addition to the work that they're already doing. Something like that, especially in a small company, would probably reduce workplace morale, and in the case of a small company, would probably amount to an undue hardship. I'll take one more example here. Let's say there's an employee who's in a car accident and is unable to work for several months. Now at first, there really may be no accommodation. The employer may just need to wait and see if the employee is even able to return to work at all. And then eventually, if the employee can come back, then the employer can engage the employee to try and find out if there's an appropriate accommodation, and if so, what it could be. Now, the Supreme Court has actually said, though, of Canada, that the employer's duty to accommodate ends where the employee is no longer able to fulfill the basic obligations associated with the employment relationship for the foreseeable future. Now, unfortunately, the term foreseeable future is not really defined in the cases, but I would suggest that the longer the employee has worked for the company, the longer it's going to take for this notion to kick in. So in summary, number one, human rights legislation requires employers to accommodate employees who have a disability as defined in the human rights legislation, but only up to the point of undue hardship. Number two, the definition of disability is broad. Number three, what amounts to an appropriate accommodation and undue hardship will largely depend on the facts of the case and also the size and the resources of the company that is at stake here. And lastly, our firm can certainly assist with these sorts of issues, so feel free to chat with us after the presentations or contact us if you need assistance. Thank you.